If you've done the Foundations Masterclass, you have Claude set up. You have a project, you have a preferences sheet, you know the 6-element brief, and you're probably getting decent output: a usable first draft, a reasonable summary, a file note that saves you 10 minutes. That's the foundation level. This episode is what comes next. The difference between a lawyer who uses Claude and a lawyer who has Claude working as part of their practice is not the setup, it's the workflow. How Claude maps onto a full matter, from instruction to close. How to brief Claude at the matter level, not just the task level. How to work across multiple documents in a single file without losing information. How to chain prompts so that each output becomes the starting point for the next step, rather than a standalone result. The delegation model, what Claude handles, what you verify, and what stays with you, regardless of how good the output looks. And the verification habit, built into every step of the workflow, not added at the end when you're under time pressure and the document already looks finished. This episode covers all of it. The free Claude for Lawyers workflow reference, every prompt from this episode in one document, with the matter lifecycle map, the briefing upgrade, the prompt chaining framework, and the delegation checklist, is in the description. Download it and have it open alongside this episode. Everything I cover, you'll be able to copy directly from the PDF into your next matter. The first thing to understand is where Claude actually sits in a full matter. Most lawyers who are new to Claude use it for isolated tasks. They ask Claude to draft one letter, or summarize one document, or generate a file note after a call. Those are useful things, but they're leaving most of the value on the table. The workflow approach is different. It maps Claude onto the full matter lifecycle and uses it at every stage, so the value compounds rather than being isolated to individual tasks. There are 5 stages where Claude adds consistent, reliable value. Stage 1 is instruction, the point when you first take on a matter. This is where most lawyers do nothing with Claude, because the matter is new and they feel like they need to get on top of it themselves first. That's exactly backwards. The cold matter brief, which we covered in the Foundations Masterclass, is most valuable at instruction, when you have a file of documents and no context. Upload the key documents, run the brief, and Claude gives you the dispute in 2 sentences: the parties, the key issues, the current position, and the 3 things you need to know before you speak to the client. Then run the chronology prompt and the party and issue map. In under 5 minutes, you have full matter orientation. That's 5 minutes instead of 40. Every time. Stage 2 is research. This is where the boundary matters most. Claude is not a research tool. It does not access Westlaw, LexisNexis, or Fastcase. Do not ask Claude to find cases for you. What Claude is genuinely useful for in the research stage is structuring the argument once you have the cases, organizing the legal issues, identifying the gaps in your position, sequencing the argument for a submission. Tell Claude the legal issues and the position you're arguing, and ask it to help you structure the reasoning. That's a legitimate and valuable use. But every case name, every statutory provision, every legal proposition gets verified on a proper research platform before it goes anywhere. Stage 3 is drafting. First draft fast, then redraft to position, then register control, then stress test before it leaves your desk. We covered the drafting workflow in depth in the Drafting with Claude episode. I'll link that in the description. At the workflow level, the key habit is to run the stress test on every substantive draft. Read it as opposing counsel. Read it as the judge. Read it as the client. Those 3 reads take 5 minutes and catch more than a second manual review. Stage 4 is review. 4 passes on every document. What's in it, what's unusual, what's ambiguous, what's missing. The 4th pass, the gap read, is the most important and the most underused. We'll come back to multi-document work in a moment. Stage 5 is close. The file note, the matter summary, the lessons extracted. Most lawyers treat close as the end of the matter. In the workflow approach, it's also the beginning of the next one. The matter summary documents what worked, what the client's position was, and what you do differently. If you have the solicitor's Claude kit installed, the file note skill runs automatically. 2 words and the file note is drafted. That's the workflow. 5 stages, Claude at every one, compounding across a full matter rather than isolated to a single task. The Foundations Masterclass covered the 6-element brief: role, recipient, purpose, register, facts, and flags. That brief is the foundation. It produces usable output. But usable is not the same as precise. For most of the work that matters in legal practice, drafting a letter that goes to a client, reviewing a contract that a deal depends on, producing an advice that someone will act on, you don't want usable. You want precise. The matter-specific brief is how you get there. Here's what the upgrade looks like in practice. The 6 elements stay. What you add is 5 things. First, matter context from your project. If you set up the matter project correctly, Claude already knows who you're acting for, whose side you're on, and what the dispute is about. You don't retype this. It's already there. The project does this work for you, which means every brief you type in that project conversation starts from a calibrated position rather than from 0. Second, a specific output structure. Tell Claude what format the output should take. Not write a letter. Write a letter with 3 sections: the factual background in 2 paragraphs, the legal position in 3 paragraphs, and the recommended next steps as a numbered list. When you specify the structure, Claude organizes information rather than sprawling it. The output is shorter, more usable, and closer to what you actually needed. Third, a scope instruction. Tell Claude exactly what to cover and what not to cover. This is the instruction most lawyers forget, and the one that makes the biggest difference to output quality. Focus only on the termination provisions is a scope instruction. Cover only the issues that affect my client's position, not the opposing party's arguments, is a scope instruction. Without a scope instruction, Claude fills the output with adjacent material that you didn't ask for and don't need. Fourth, a stop instruction. Tell Claude where to finish and what not to add after. Do not add a summary section. Do not include general commentary on the document. Stop when you have covered all the risk clauses. Claude has a tendency to close with a paragraph of general context that nobody asked for. A stop instruction removes it. Fifth, the verification instruction, in the brief, not just in project. Flag anything uncertain with verify. Do not state uncertain propositions as fact. This goes in every brief where the output matters, not in the project instructions only, in the brief itself, every time. We'll come back to why this matters in the verification section. Here is the practical test for whether your brief is specific enough. Read it back to yourself and ask, could this brief apply to any contract, or does it describe this specific matter? If the answer is any contract, the brief is not specific enough. A brief that names the parties, the specific clause you're reviewing, the specific risk you're looking for, and the specific format you need to be output in, that's a matter-specific brief. That's the upgrade. One document is straightforward. You upload it, you brief Claude, you get output. A full matter file is more complex, and this is where most lawyers either don't know Claude can help or brief it poorly and get weak output. There are 3 principles for working across multiple documents in a single matter. The first is to upload in sequence and name each document before Claude reads it. This sounds obvious, but most lawyers don't do it. They upload 3 documents and ask Claude to summarize them. Claude reads them in order and produces a combined summary that loses the distinction between what each document says. The better approach is to tell Claude what it's reading before it reads it. Document 1 is the contract dated the 1st of March. Document 2 is the client's letter of instruction dated the 15th of March. Document 3 is the opposing party's response dated the 22nd of March. Read all 3 before you begin, and do not start your analysis until you have read all of them. That instruction changes the output completely. Claude now has the full picture before it starts, rather than building its analysis incrementally as it reads. The second principle is to cross-reference explicitly. Claude will not automatically compare documents unless you ask it to. If you want to know where the contract conflicts with the client's instructions, you have to name both documents and ask for the comparison directly. Where does document 1 conflict with document 2? List every point of conflict, identify which document is more favorable to my client on each point, and flag any conflict that requires a decision before we proceed. That prompt produces a usable conflict analysis. Summarize these documents does not. The third principle is to extract with structure rather than summarize. This is the most important distinction in multi-document work. A summary loses information. It compresses, combines, and removes detail. An extraction preserves it. When you need to work across a full file, ask Claude to extract specific things in a specific structure. Extract every date, every obligation, every party, and every condition precedent across all 3 documents. Present this as a table with 5 columns: document, date, obligation, party responsible, and deadline. What comes back is a structured reference you can use, not a paragraph that compresses everything into something you then have to re-expand. Extract. Don't summarize. That's the rule for multi-document work. Most lawyers use Claude as a one-shot tool. 1 prompt, 1 output, done. That works for simple tasks. For complex work, an advice letter, a submission, a contract review that feeds into a negotiation position, a single prompt rarely produces the best output. The reason is that good legal work is sequential. You identify the issues before you structure the argument. You structure the argument before you draft. You draft before you stress test. Prompt chaining applies that sequence to Claude. Each output becomes the input for the next prompt, and the quality compounds at every step. Here is a 4-step chain for any advisory matter. Step 1. Cold matter brief to issue list. You've already run the cold matter brief, and Claude has given you full matter orientation. Now you use that output as the starting point for the next prompt. Based on the matter brief you just produced, list the 5 legal issues I need to advise on in order of priority. For each issue, give me 1 sentence on the relevant legal principle and 1 sentence on my client's current position. That output is the issue list, and it's grounded in the specific matter, not a generic treatment of the topic. Step 2. Issue list to advice structure. Using the issue list you just produced, draft the structure of an advice letter. Headings only, no content yet. 1 heading per issue in the same priority order. Add a brief note under each heading describing what that section needs to achieve. What comes back is the skeleton of the letter, the architecture before the content. You review it, adjust the order if needed, and then move to Step 3. Step 3. Structure to first draft, 1 section at a time. This is where most lawyers try to do everything in 1 prompt and get bloated output. The better approach is to draft 1 section at a time. Now draft the first section only, the factual background. Plain, direct legal English. No legalese, no boilerplate. Flag anything uncertain with verify. Stop at the end of this section. You review it, make any changes, then move to the next section. Drafting in sections keeps each part tight and means you're reviewing as you go rather than facing a wall of text at the end. Step 4. Draft to stress test. Once each section is drafted and reviewed, run the client read. Read this section as my client receiving it for the first time. They are not a lawyer. What would they not understand? What would they question? What would they want explained before they could act on it? That read catches the assumptions you've made as a lawyer that the client won't share. Plain language issues, missing context, recommendations that aren't actionable. These are the things that generate follow-up calls. The stress test catches them before the letter goes out. The quality at Step 4 is entirely determined by the quality at Step 1. A weak matter brief produces a weak issue list, which produces a weak structure, which produces a weak draft. A precise matter brief produces a precise issue list, and the quality compounds from there. This is why the briefing upgrade in the previous section matters so much. The brief is not just 1 prompt. It's the foundation of the entire chain. Claude is not a junior lawyer. It's not a paralegal. It's a completely different kind of resource, with a completely different accountability structure. A junior lawyer who produces a weak draft is professionally accountable for that draft. You can train them, supervise them, and hold them to a standard. Claude is not accountable for anything. You are accountable for everything that goes out under your name, regardless of how it was produced. That distinction is not a reason not to use Claude. It's a reason to be clear about what you're delegating and what you're retaining. What belongs in the delegate column is substantial. First drafts of standard documents, letters, file notes, memos, contract reviews, advice structures. Matter intake and orientation, the cold matter brief, the chronology, the party and issue map. Document triage and extraction across a full file. Redraft and register adjustment, hardening a position, softening a tone, changing the register for a different audience. Stress testing your own work, asking Claude to read your draft as opposing counsel, as the judge, as the client. These are all high-value uses of Claude that save significant time without crossing any professional line. What belongs in the review and verify column is equally clear. Everything Claude produces before it goes anywhere. Not most things, not the things that seem important. Everything. Every verify flag cleared against a primary source. Every citation checked on Westlaw, LexisNexis, or Fastcase. Not on Google, not by asking Claude to check itself. Every factual assertion confirmed against the documents in the record. This is not optional, and it is not a formality. The firms that have faced public consequences for AI output in the courts skipped this step. Garfield AI, which won a contested trial with AI-drafted documents, built this step into their process. The difference is not the tool, it's the workflow around it. What stays with you, and this is the column that never changes, regardless of how good the AI output gets, is professional judgment. Strategic decisions about a matter. Advice that depends on your professional accountability. The decision about whether the output is good enough to go out under your name. Claude does not make that decision. Claude produces a draft. You decide whether it meets the standard. That is always yours. No workflow changes it. Verification built into the workflow is different from verification as a final check. That distinction sounds subtle. It isn't. When verification is a final check, you're reviewing a document that looks finished. It's formatted. It reads well. The structure is there. Psychologically, you're looking for reasons to send it, not reasons to stop. Under time pressure, which is when most legal documents get their final review, this means the uncertainty gets missed. Not because you're careless, because the document looks finished and your brain treats it as finished. When verification is built into each prompt, the uncertainty is visible in the output from the moment it's produced. The verify flag sits in line, next to the sentence that Claude isn't confident about. You see it when you're reviewing the output, not when you're checking a document you're trying to get out the door. The flag is right there. You know exactly what to check. You check it before the document progresses to the next step. That's the difference. Two instructions make this work. The first is the verify instruction in every prompt where the output matters. Flag anything uncertain with verify. Do not state uncertain propositions as fact. Not in the project instructions only. In every prompt. The reason it goes in every prompt rather than just the project is that Claude's confidence about what to flag varies with the task. A project instruction sets a general level of caution. A prompt level instruction applies to this specific output and this specific task. Both matter. The second is the factual accuracy prompt. Run it before any document goes out. Compare every factual assertion in this output against the documents I provided. Flag any assertion that is not supported by a document in the record or where the document says something different from what is asserted. This prompt catches the factual drift that happens during drafting, where the output has moved slightly away from what the documents actually say. Sometimes Claude fills a gap with what usually comes next. Sometimes it uses a training pattern that doesn't quite match your matter. The factual accuracy prompt finds those drifts before they become errors in a document that goes to a client or a court. A complete verification protocol for legal practice, the 5-point system, the supervision checklist for junior use, the firm-wide deployment framework, is coming to this channel as a dedicated product. These two instructions are the habit that sits underneath it. Build them in now. Everything from this episode is in the Claude for Lawyers workflow reference. Free download, link in the description. What's in it? The matter lifecycle map with Claude at every stage. The briefing upgrade in full. All 5 additions to the 6-element brief explained and copy-ready. The multi-document work principles with the exact prompts. The 4-step prompt chaining framework. The delegation checklist. What Claude handles, what you verify, what stays with you. And the 2 verification instructions that go into every prompt. Download it, have it open on your next matter, and use it as a reference until the workflow is second nature. It's at claudeforlawyers.gumroad.com. And while you're there, you'll see the other products on the channel. The Monday morning setup is the entry point. It gets your Claude configured for your practice in 10 minutes with a pre-written system prompt template, a preferences sheet, and the Monday morning checklist. If you haven't done that yet, start there. The Solicitor's Claude Kit takes you further. 3 installed skills that run the contract review, advice letter, and file note workflows automatically without typing anything. And the beginner courses, Claude AI for lawyers, Claude Cowork for lawyers, and Claude AI for paralegals and legal secretaries are the right starting point for junior staff and support teams who need to learn the fundamentals before the workflow level. All of it is at claudeforlawyers.gumroad.com. Matter lifecycle. Claude at every stage from instruction to close, compounding across the full matter rather than isolated to individual tasks. The briefing upgrade. 5 additions to the 6-element brief that take output from usable to precise. Multi-document work. Upload in sequence. Cross-reference explicitly. Extract with structure. Prompt chaining. 4 steps, each output becoming the input for the next. Quality compounding at every stage. The delegation model. Delegate the drafting, verify the output, retain the judgment. And the verification habit. Built into every prompt, not added at the end when the document already looks finished. That's the complete intermediate Claude workflow for legal practice. The free workflow reference is in the description. Everything from this episode, ready to use on your next matter. That's the episode. See you in the next one.